Ladies and gentlemen, welcome to the main event.
All right, let's dive right in. Here's something that might throw you off. The Supreme Court of the United States just made it harder for veterans to win certain VA appeals. Sounds odd, right? The Supreme Court is supposed to be looking out for veterans, not making things tougher for us.
Yeah, that definitely doesn't sound like the usual narrative. The Supreme Court protecting veterans has been the norm for so long. What happened?
It's all about a case called Buffkin versus Collins. For decades, the law was clear: if your evidence and the VA's evidence were about even, the VA had to give you the benefit of the doubt. It wasn't just a nice gesture, it was a part of federal law, specifically written into 38 CFR. That's been a cornerstone for veterans' claims since the post-Civil War era.
So if things were tied, veterans would get the benefit of the doubt. It sounds like a pretty fair system. But now, with Buffkin versus Collins, that's changed?
Exactly. The Supreme Court changed how courts interpret the balance of evidence. Before, if the evidence was about 50/50, the VA had to rule in the veteran's favor. But now, the VA's version of the truth carries more weight.
That's a huge shift. So even if the evidence is balanced, the VA's decision might still stand unless it's a clear error?
Yep, and that's where it gets tricky. Now, if the VA's interpretation of the evidence is only slightly off, it can still stand. You can't just challenge the balance of evidence anymore. It has to be a glaring mistake, something they really messed up.
So the benefit of the doubt isn't really benefiting veterans like it used to. What's the real-world impact of this change?
Think about it. You file a claim for PTSD, back pain, migraines, whatever it may be. You've got two doctors saying, yes, this is service-related. One VA doctor says, nope, I disagree. Before Buffkin, you had a solid shot. But now, after Buffkin, the courts can't reweigh the evidence. They can only say, was this a clear error? And that bar is set really high.
It sounds like the VA's decision is pretty much locked in unless it's a massive error. So what can veterans do to protect themselves in this new environment?
First and foremost, make your evidence bulletproof. If the VA is going to weigh your evidence, make sure it's as clear and strong as possible, and don't rely on vague language from your doctor. It's got to be specific. Phrases like "at least as likely as not" carry legal weight, and that could make all the difference.
Right? And that's not something every doctor knows how to write. Most civilian doctors aren't used to writing medical opinions that stand up in court.
Exactly. Many doctors are great at diagnosing and treating, but they're not trained in writing legal opinions. That's why veterans need to take control of their case from the start. Make sure your doctor's opinions are clear, specific, and backed by solid reasoning.
So, step 1 is making your medical evidence bulletproof. What's next?
Step 2, challenge factual mistakes early. Once a fact is set, it's nearly impossible to change. If the VA gets a detail wrong, like a date, a symptom, or a statement, correct it right away. Don't wait until the appeal stage. By then, the court can only look for clear errors, not factual mistakes.
That sounds like a critical step. If a mistake gets locked into the record, it could cost a veteran their claim, even if it's a small error.
Exactly. If your claim is borderline, like in the case of PTSD or chronic pain, those little inaccuracies could snowball into a denial. The appeal courts won't review the facts, they'll only check if there's a clear mistake. So, you need to catch those errors before they become part of the permanent record.
So, it's about being proactive, right? Catching those mistakes while you still can.
Yes, and that leads into the third step, keeping your own paper trail. Every doctor's visit, every symptom journal, and every letter you receive from the VA, that's your backup. The VA's version of your story can't become the official record unless you've got the right evidence to fight it.
It sounds like it's not just about filing a claim. It's about maintaining an ongoing record that supports your story.
Exactly. You can't just trust the VA to get it right. Keep your own copies of everything: medical notes, VA letters, emails. That way, when the VA misses something, you've got your own archive to back you up.
It's almost like building your own defense case. You've got to have all the facts lined up, organized, and ready to go.
And that's the key to winning under the new rules. Buffkin versus Collins didn't take away the benefit of the doubt, but it made it a lot harder to get it. Now, veterans need to fight smarter, not just in the courtroom, but in the documentation.
So if you understand these changes and prepare your case with solid evidence, you can still win, even with this new system.
Exactly. It's all about being strategic. The VA is a tough system, but with the right preparation, veterans can still come out on top.
Well, that's a good place to wrap up for today. For anyone out there who might be dealing with a VA claim, the takeaway is clear. Make sure your evidence is airtight, stay on top of any factual mistakes, and keep a detailed paper trail. The battlefield may have shifted, but your weapon is still your evidence.
And don't get discouraged. It's not over. Just understand the new rules, and you can still fight and win. Stay tuned, because next time we're going to dive into special monthly compensation, something a lot of veterans don't even realize they might qualify for. You definitely don't want to miss it.
Absolutely. See you next time.
A special thank you to MarketUS.com for furnishing us this information. You can reach them at MarketUS.com or call them at 954-636-3232. Before we go, this deep dive was created by the MarketUS.com team. Let us know your thoughts in the comments below. It's right below the subscribe link.